for summary judgment and no evidence, motion for summary judgment. I appreciate Your Honor has already read the briefing, so I don't know, we only have 50 minutes, so I'll try to be short and to the point. We believe that the Dallas Oil can't survive summary judgment, and that the two causes of action, breach of contract and tortious interference with contract, should be dismissed as a matter of law. First and foremost, on the breach of contract claim, the contract at issue here, as Your Honor is aware, was a non-competition, non-solicitation agreement that the plaintiff had with his former employee, Mr. Mulholland. There was the plaintiff early on in the case tried to obtain a temporary restraining order. That was not granted. And then prior to a temporary injunction hearing, the parties submitted an agreed temporary injunction order, which mirrored one that had been entered by Judge Smith in a almost identical case against another individual, in which that court found that the agreement that the plaintiff was seeking to enforce was unreasonable because it was seeking to bar him from working in the industry entirely for 5 years. The court reformed that agreement, as it has the power to do. And then prior to having a temporary injunction in this case, the parties agreed to enter the same injunction, which the court entered here, reforming Mr. Mulholland's agreement as well to only a non-solicitation for a limited period of 1 year and for only within 150 miles of Dallas Oil. So the court entered an order reforming the agreement. The word reform is actually in the agreed injunction that the court entered. And we believe, as a matter of law, any alleged breaches that occurred prior to reformation, the plaintiff can't get any damages for. The statute is clear under section 15.51C that prior to, if the court reforms the agreement because it's unreasonable, which the court did here, the plaintiff cannot recover damages for any breaches that predated reformation. The only evidence that the plaintiff has put forth in this case at all consists of alleged breaches that predated December 11, 2020. That's it. And so, as a matter of law, the plaintiff cannot recover damages for any of those acts. But even if it could, secondly, Your Honor, we believe the plaintiff is not entitled to recovery against Mr. Mulholland. First and foremost, and we filed an objection motion to strike, the evidence in the form of Mr. Slaughter's affidavit is almost entirely inadmissible. It's conclusory. It's lacking in any evidentiary or factual basis. But even if it's admissible, Mr. Slaughter's alleged damages that he testifies to are for gross revenues. You cannot recover gross revenues as damages for violation of a non-solicitation agreement. The proper recovery is net profits. Mr. Slaughter offers zero evidence of the alleged net profits lost. He only offers evidence of gross revenues, which are not recoverable at all. So that's the second reason why the plaintiff cannot recover here. And finally, with respect to these alleged customers who were lost, there's no evidence in the record in the form of Mr. Slaughter's affidavit or otherwise as to why these customers left. It's undisputed. They didn't even have a contract, first of all. They certainly didn't have an exclusive contract. And so the customers can leave whenever they choose to. And Mr. Slaughter offers no evidence that these customers even went to Mr. Mulholland's new employer, only that the customers left. So there's a causal link missing there, which is evidence from the customers themselves stating, we left because Mr. Mulholland solicited us and we went to his new employer. That evidence does not exist. This is exactly like the AZZ Inc. v. Morgan case, which we cited in our brief, in which the Fort Worth Court of Appeals found there was no competent evidence of damages because the plaintiff failed to put forth any evidence why the customer decided to leave, and the customer was free to do so because it didn't have an exclusive contract. It's exactly like the case we have here. Finally, Your Honor, with respect to the tortious interference claim, again, there's no evidence of a contract here. The only evidence of an alleged contract is this order slip, and we attach that to our motion. That's not a contract. It's not signed by both parties. It doesn't have all material terms. And Mr. Slaughter testified unequivocally that it doesn't have exclusive contracts. So absent a contract, you obviously cannot have a tortious interference with contract claim. Moreover, with respect to the damages, for the same reason, the same damages are being sought for the tortious interference claim as the breach of contract claim, and they fail for the same exact reason. Finally, Your Honor, with respect to attorney's fees, we don't even think we get there because if Your Honor grants the motion, obviously the plaintiff wouldn't be entitled to attorney's fees. But even if the plaintiff were somehow able to prove a breach of contract claim, attorney's fees simply are not recoverable by an employer against an employee in a non-compete case. The statute could not be clearer on that. It's section 15.52, which the Texas Business Commerce Code, which says that it is exclusive and preempts all other law, which includes the common law that a party can include a contractual provision to attorney's fees, which this contract has. That is preempted. And we cite 5 or 6 cases, including the Glatley case, in which every single court that's looked at this particular issue has said that preemption means that an employer cannot recover attorney's fees against an employee in a non-compete case, even if the employer prevails. So for those reasons, Your Honor, we think that the court should grant the motion for summary judgment and dismiss all of the plaintiff's claims against Mr. Mulholland with prejudice. Thank you.
Response?
Yes, sir. Yes, sir. Since he's chosen to mention the 192nd case, the administrative judge who over the Dallas courts that heard the case dismissed and denied both motions for summary judgment in that case, identical motions. In this matter, what he has failed to mention is he's addressed only contractual claims. We have a tortious interference with contract claim as well. He didn't address that at all. In regard to what he has said here, Your Honor, we have cited there are other courts of appeal who do not agree with what he said. We cited the Butler versus Aeroglass and Merrill Company case out of Houston. They look at this as a contract case and they look at it quite differently than the other. It's not definitive as far as what he is saying. Now, what I would suggest to the court is that he says, first of all, there's no evidence. I took the oral deposition of Steve Mulholland. He admitted under oath to contacting 21 people immediately after he went to work for H&H Oil Company, which is a direct competitor of Dallas Oil, in violation of the covenant not to compete immediately after he terminated his employment. We also have shown by his own testimony that 16 of those customers went to H&H Oil Company that he personally contacted. He admitted to all of these things. So it's not just a matter of the affidavit of my client, it's the admissions of their own defendant that he did it. He has caused, and what we approved is $184,000 in damage. So it is not a small amount of money that we're talking about here. To say that we haven't met it, I mean, there's been, as far as the elements of contract, there's no dispute that there was a valid contract. There's no dispute that that the plaintiff offered and did its part. There's no dispute that it was breached. He admitted the breach. There's no dispute as to damage. We're only required to produce a scintilla of proof, which court knows more than a scintilla of evidence on each point. We've done more than that. We've almost proved it beyond a reasonable doubt. In this case, much more than a civil case. In the tortious interference with contract, same deal. We proved every element of that. We've had, and basically what we have relied upon is his own admissions that he did it and that he did it in violation of the contract. I cited that in my brief. I asked him if he did contact the people. He admitted he contacted the people. I went down a list of 83 people that were lost to Dallas Oil and went one customer at a time and had him admit, and we checked them off. And that's how we came up with a figure of, by his own admission, of contacting 21 people and him taking 16 of those people. Honestly, I don't know how it could be a stronger case against summary judgment than what we approved. I mean, if you have the guy admit that he did all of those things. I don't know what more you need than that.
What do you make of this what do you make of this argument that you can only consider any type of breaches that occurred after the reformation of the contract?
I think it's completely distinguishable, and that's what I dealt with in my brief, Your Honor. In the case that he was talking about, the 192nd, we had a full factual hearing before Judge Smith, and then he made a determination at that time that he thought it was beyond what it should be as far as time, not as far as distance, geographical area, any of those things. He said it ought to be a year. We did not have a hearing in this court. This court didn't have a full factual hearing. There was no decision by this court. All that happened here is we submitted an agreed order to the court. The parties themselves compromised and agreed to change the time limit to a year. That's it. So I think it's completely inapplicable as far as 1551. I think that is a very narrow exception, or a point that he has to show is that the court itself made a formal reformation, not that the parties agreed to do that. So I think that's completely distinguishable and inapplicable in this case.
All right, response. Mr. Wood, you're muted.
Yeah, I'm on mute. Sorry, Your Honor. I think it's absolutely applicable. There's nothing in section 15.51C that says anything, and you can't cite to any law which requires that there be a full-blown evidentiary hearing. The statute on its face says if the covenant is found to contain restrictions that are not reasonable, the court shall reform it, and the court cannot award damages for any breach prior to reformation. Yes, we did enter into an agreement here because Dallas Oil knew that this court was likely to do the same thing the other court did, which is find that 5 years was unreasonable. It doesn't say anything about distance in here. It just says if the court is required to reform it. And this court did. It's actually in the order that the court entered. The word reformation is in there twice. The court had to sign off on the parties' agreement. The court did so. It found that the agreement needed to be reformed from 5 years to 1 year, and that's what it did. There's nothing, and there's no case law whatsoever that says there has to be a full-blown evidentiary hearing. The court entered its finding as it was bound to do. With respect to this argument that Mr. Mulholland admitted to soliciting 21 customers, that's not at all what he testified to. If you actually look at his deposition testimony, he didn't admit soliciting 21 customers, and he certainly didn't admit that all of them went to work at Dallas Oil or went to work at his new employer. But again, even if he had, every single contact was prior to reformation, period. They haven't put forth a single contact by Mr. Mulholland with any customer after December 11, 2020, which was the date of reformation. So, but again,
how do you
Your Honor,
distinguish what happened in this court versus the 192nd?
with respect to the temporary injunction?
Yeah.
Well, again, we had the temporary injunction hearing in that court.
No, I mean, in the other court, apparently that's the judge, I assume that's Judge Wheelis. He denied the summary judgment in that, apparently an identical summary judgment in that case. How do you distinguish?
Your Honor, I wish I knew what Judge Wheelis was thinking, because he didn't rule while we were in court. We got an order later that day, so we have no way of knowing why he ruled the way he did. We disagree with the ruling. The motions were similar, and we think that motion should have been granted too. But as far as the reasoning for him denying it, I'm not sure. But this case, we believe, this motion stands on its own. We believe that it should be granted on behalf of Mr. Mulholland. Mr. Neptune, the other party, will have to, deal with that court when he goes to trial. But again, I think that this motion can and should be granted on its own merits.
Okay. I'm going to go ahead and deny the motion as well. That doesn't mean that at the time of trial, if there's no evidence, if you want to brief this issue at trial and the that shows that there's no evidence of breach after the time of reformation, then I won't consider it at that point. But at this point, I'm denying the summary judgment. Anything else?
No, sir. Thank you.
No, Your Honor.
Thank you, guys. Did you already submit an order on this?
I think I did, Your Honor, but I will submit another one.
On the
If
order,
that's
if you
all right,
could
I'll
go
just
ahead
electron-
and on the order, if you could go ahead and put that this was heard on instead of at the beginning where it says on this date, put on January 10th, 2022, the court heard the following. Go ahead and submit that to Rhonda and to Mr. Wood, and then e-file it with the court as well. Okay.
I'll do it, Your Honor. Yes, sir. Thank you.
Guys.
Thank you.
Thank you, sir.
All right. Do we have another hearing for 11:15?
Yes, Your Honor. I think we're all present.
All right, that's on International Offset Corporation versus 4G Holdings.
Yes, Your Honor.
Yes, Your Honor.
All right, let's go ahead and proceed. Do you want a record on this?
Your Honor, I don't need a record.
Your Honor, this is Sean McCaskill for the plaintiff. We also have a motion with respect to exceeding the page limits. So I know it's a summary judgment. I understand we don't need a record for that, but given that we have an ancillary motion, if you will, I would request a record just in case we get into that at all. And I wasn't planning on addressing it till the end.
Let me just say that I have never a single time enforced that. That was something that was kind of adopted at the beginning of the pandemic when we didn't know if the world was going to completely fall apart. And so, and there's some judges, I guess, that still enforce it. I've never enforced it, so I'm not going to enforce it here either. So I don't know who filed it. I may have already signed the order. I signed a bunch of those orders this weekend, but
it was the plaintiff that filed the motion with our response to defendant's motion. And with that, I totally understand and appreciate that, Judge. So with that, no, I don't think a record is required of the hearing. I'll let Mr. Strother present his motion.
go ahead and proceed.
Thank you, Your Honor. And to highlight the collegiality between myself and opposing counsel, I would like to pat myself on the back and say we did not oppose the page limit extension. We were
Okay, good.
happy to jump on board with that.
We'll stipulate to that.
But the goodwill ends there because we have filed a motion for summary judgment, both traditional and no evidence. Your Honor, I'm Justin Strother with Diamond McCarthy. I represent all of the defendants in this case. I also have my associate, Julian Sokich, here. And with the court's permission, while I'm going to do the majority of the argument, there's one issue that I would like Mr. Sokich to address. He's an associate, and I'd like to get him the argument time. However, he's also the intra-firm expert in this particular issue. So, Your Honor, would that be okay, time pending?
Sure.
Okay. Your Honor, as I said, we represent the defendants. We have filed a motion for summary judgment on a variety of plaintiffs' claims. And as I mentioned, I'm going to be arguing most of them. I'm going to attempt to address them in order of what I think the low-hanging fruit is. I'd like to spend a moment and go into the background about what the dispute is about and who the parties are real fast. Your Honor, the plaintiff in this lawsuit is International Offset Corporation, and it goes by IOC. The identity of that plaintiff is more important than just me introducing who the parties are. It's important because one of our big—
Can I ask a question? I've read the briefing on this, and one thing that wasn't 100% clear to me, why did you bring suit in the name of IOC as opposed to the affiliate that actually, I guess, entered into the contract?
And Your Honor, that's a question for Mr. McCaskill. So I don't know if you're asking.
Well, let's let him answer it then.
Yes, thank you, Judge. May it please the court, Sean McCaskill and Charmaine Becken on behalf of the plaintiff, IOC. And just to pass along, Ms. Becken is not able to join us today with a health-related issue, and so she apologizes for not being here to present her part of the motion, but I'll try to do it justice. To your question, Your Honor, we're not suing for a breach of contract, a breach of the barter agreement between the defendant entity 4G and a company called Artis, ARTIS. And I think Your Honor stated, you're familiar with the briefing here. Mr. Talbert, Matthew Talbert, my client, is the owner of both entities, Artis and IOC. And the reason why this is not a breach of contract case involving breach of the barter agreement is because he's very clear in his deposition and also in his affidavit, and there's no objections to any of that evidence that we've submitted, is that Artis handles domestic US-based types of deals. And when this deal became an international deal involving the gluco reverse product in Mexico, that became an IOC deal. They handle international barter transactions and consulting and business assistance programs. So that's a short answer. Also, the idea that the defendants didn't know about IOC or didn't know who they were dealing with, we've responded to that in our response, that they seem to be complaining we weren't sure which hat Mr. Talbert was wearing. They're not complaining or suggesting that they didn't make these statements in emails or statements orally. They're saying we just didn't know which hat Mr. Talbert was wearing, whether it was the Artis hat or the IOC hat. But given it was an international deal in Mexico, that's why it's an IOC claim and it's not a breach of contract brought by the domestic entity Artis.
Okay,
Your Honor, may I address that?
you may go ahead.
Okay, Your Honor, this is getting into our standing argument, which is fine. I will say I was going to address standing after damages, because when I decided what's the lowest hanging fruit, I'll admit they were both almost touching the ground. But let me go into standing. First of all, to correct a couple of the things Mr. McCaskill said about my client's allegations. My client, in its motion for summary judgment, definitely does contest having said a variety of things or having made various alleged misrepresentations. So to the extent he was accidentally saying that we weren't contesting that, we definitely are. This is not an issue of us not knowing which hat Mr. Talbert was wearing. It's an issue of us not knowing that he had the hat in his closet to begin with. Mr. Talbert's argument, with no evidence is to support it, is simply that because this transaction was going to occur internationally, he took off the Artis hat and put on his IOC hat. He owns both entities. He's 100% owner of both and controls them both. But the written agreement between the parties that governs this international transaction was with Artis. And so the reason Artis is no longer the plaintiff in this lawsuit is because if Artis loses, Artis pays attorney's fees. IOC, not being a party to that agreement, doesn't have the same risk involved. So the concept that Mr. Talbert can put on a hat and all of a sudden change who the representations are being made to, that is unfair, especially to do it in secret. The only possible evidence that Mr. Talbert has, the only thing that he submitted, is that the emails that he was receiving and sending regarding the Artis transaction were actually his IOC email. I think it was ioccorp.org. He provided no evidence that he actually has an Artis email address. And given that he moved to Texas in 2019, formed the entities in Texas, entered into the agreement in early 2020, and then within months threatened and filed a suit and now has terminated the entities and moved to Florida, I don't know that he has. It's not before the court that he has this Artis email. But plaintiffs don't even attempt to provide any probative value to the concept that, hey, because I was using this, I'm IOC at gmail.com, you should have known that you were actually speaking to me when I was wearing my IOC hat. That's the extent of their standing argument, Your Honor.
Okay, go ahead.
So let me address the damages, Your Honor, because while, as you can tell, I strongly feel that this case should be dismissed on standing grounds. And if Artis wants to pursue a lawsuit on breach of contract, it can do so, or fraud. The damages might even be easier for this court to look at and slice off. IOC is seeking 6 categories of damages, and we have independently moved for summary judgment on each of those 6. And we provided a checklist order for the court after the hearing to look at and hopefully grant them all. But you'll have the opportunity, of course, to see them all laid out in an order form. I think that the best place to begin is with some of the larger categories, and some of the larger actually being the ones with the least to no amount of evidence. The first one, Your Honor, is IOC is seeking lost profits. That is the biggest hurdle that IOC has to jump over in this case, I believe. The Texas Supreme Court has held since 1992 that to recover and prove lost profits, a plaintiff has to have competent evidence that is reasonably certain. Those two words, reasonably certain, are crucial here because plaintiff hasn't even attempted to meet that standard. That case, Your Honor, is the Holt-Atherton case, and it has stood up as good law and has progeny. There's no question that Texas requires the evidence to be reasonably certain. One of the cases that we cited, Your Honor, is the SBC, the SBC operations case. And that one's a really good one to look at, Your Honor, because it shows just how high the hurdle is. In that case, the plaintiff was seeking lost profits and it designated not one, but two experts who had, as the court conceded, vast experience in the field. And they had created calculations with mathematical precision. They had projections of costs and revenues. They looked at estimated costs of marketing materials and purchase rates of the products. And the court in that case said, fine and dandy, these are great experts, but they are not using actual data. And that's the actual quote, Your Honor, actual data, and therefore they're not objective facts. Plaintiff, in response to our no evidence motion for summary judgment, provided literally no objective fact and no actual data. They merely say, with regard to this untested, unmarketed product in Mexico, gluco-reverse, that Mr. Talbert could have increased the value of 4G, my client, by 3 times to 10 times. And so they just wet their finger and stick it in there and say, so we want $1 million in lost profits. That's an outlandish argument that doesn't come close to reasonably certain. The second category, which likewise is completely lacking, is that plaintiff is seeking $1 million worth of stock in my client, 4G. We think we did a good job in our motion, but plaintiff actually proved our point with its evidence and its response. And so I would like to address it from that angle. In plaintiff's response, they provided cite to 4 different times when plaintiff concedes that the argument for $1 million in stock belongs to Artis, no longer a party to this lawsuit, Artis and not IOC. I cited the page numbers, but they're in plaintiff's response at 9:31. This is the appendix, by the way, Your Honor. Mr. Talbert's affidavit at 37 and Mr. Talbert's deposition at page 127 of plaintiff's appendix. They admit not only that my client was required to give stock to Artis, but that my client did give stock to the company that Artis directed. And as the facts would prove, and by the way, this is not contested, 4G did issue a stock certificate to the company that Artis wanted it to. It just wasn't IOC. It wasn't even Artis. Mr. Talbert had 4G issue that stock to a third entity that he owns that does nothing but hold things called Bragavan Holdings. That fact is uncontested. There's no other evidence that IOC has any claim to stock. I'm not glossing over it. There's just literally no other evidence. The third category is plaintiff is seeking about $171,000 in consulting time. And when we filed the motion for summary judgment, my clients were very worried. They're wringing their hands thinking, what is plaintiff going to come up with here? All he's done to that point is give his deposition and said the following things. I estimate I worked on this project for, and I could be wrong on the weeks and the hours, 13 weeks. And I estimate each day during each of those weeks, I worked 7 hours, 6 hours, whatever the number was. That's a total of blank hours. I want $850 per hour for that estimated time. Do you have any receipts? Do you have any calendar entries? Do you have any business plans that you created, communications that document not just all of these hours during all of those weeks, but one of them? No. Literally no written evidence to document that. However, Mr. Talbert did concede that the written agreement with Artis not IOC, said that if my client 4G wanted any consulting from Mr. Talbert, it would request it in writing, and that Mr. Talbert would provide it at $850 an hour. But that was Artis. And by the way, Mr. Talbert conceded that no such written request was ever made. So this is not just a standing issue, it's a lack of evidence issue. Plaintiff cannot at this no evidence stage say, I estimate I spent X hours, Y estimate of weeks, I'm applying that at $850 an hour. And by the way, the final thing on that, Your Honor, is that Mr. Talbert did acknowledge and admit that he can't think of anyone that's ever paid him $850 an hour. The final of the 6 categories of evidence that IOC attempted to rebut is lost other business opportunities. I say the last of the 6, and I've only talked about 4, because 2 of them plaintiff has apparently dropped. They didn't pay even lip service to those 2. I'll mention them in a moment. The lost other business opportunities that plaintiffs are seeking are described by plaintiff as lost other business opportunities. There's no dollar figure. There's no name of a client or potential client. There's no track record. There's no idea that there are irons in the fire. It's literally nothing more than we are suing you for lost other business opportunities. We acknowledge that you're filing a no evidence motion for summary judgment, but there are deals that we didn't work on and that we didn't consummate because we were working on this one. That's literally all the evidence. Except that I will say that in Mr. Talbert's deposition, which was attached to plaintiff's response, he was asked by me, hey, what evidence do you have? Who are these other people that you were going to do work for? And he looked at his attorney and said, do I have to answer that? The answer was basically, if you want that, yes. And he said, on the record, under oath, I am not going to pursue that element of damages then. He's apparently changed his mind, but he's not attempted to provide any evidence of that. The other 2 things, Your Honor, that plaintiffs didn't even put on evidence of in response, they didn't even mention, was $20,000 in expenses and an unnumbered amount for business for advertising expenses. So those 2 are automatically dropped. Your Honor, I've already addressed standing and I have now addressed damages. I think I would, with the court's permission, like to turn it over to Mr. Sokich so he can address the fact that there are these individuals that plaintiff has sued, but that they probably should be let out of the case.
Okay, well, why don't we do these one at a time? So, Mr. McCaskill, why don't you respond to these 6 points?
Yes, Your Honor, and if it's okay with Your Honor, I'll go back to the standing quickly and then move into the damages and then turn it back over to defendants on their last point. On the standing, Your Honor, again, as I alluded to a little bit earlier, Mr. Talbert owns both of these entities, Artis and IOC, and this idea that the defendants didn't know who they were dealing with is betrayed by the evidence. And again, none of our evidence that we submitted to the court has been objected to. So when Mr. Strother says, well, they didn't prove this up, well, we have emails, we have deposition testimony, and we have Mr. Talbert's affidavit, none of which was objected to. So while Mr. Strother and I can disagree as to what the jury might do with that evidence, we do have evidence that survives or allows us to survive summary judgment. On the issue of standing, not only do we have the issue with the IOC email address where the defendants were communicating with Mr. Talbert through the IOC corporate domain, but there's also testimony, or there's also emails from Mr. Varghese, one of the individual named defendants, and he's also the president of Defendant 4G, where he's referring to Mr. Talbert and IOC as a partner and a strategic partner. So the fact that they're not referring to Artis as their partner, they're not referring to Artis at all. When they're talking about partner, and that's a quote, partner or quote, strategic partner, end quote, they're not talking about Artis. They're talking about Mr. Talbert and IOC.
So remind me again, Mr. McCaskill, what are your causes of action?
Fraud and negligent misrepresentation. This is not a breach of contract case or breach of the barter agreement. This became a fraud case, and we've laid out, I think it's on page 2 of our response, there are 6 categories of fraud and negligent misrepresentation where we allege that the defendants misstated, misrepresented, or concealed information regarding 4G and this glucose reverse product. And so if we survive on any of those 6 allegations, and I know under the time constraints, we probably won't touch them all during argument, but those are the causes of action, and there's 6 allegations that underpin those causes of action. Your Honor, jumping ahead to the issue of the shareholding, early in this case, the defendants took the position that my client was not even a shareholder in 4G. That was part of the basis for them asserting we didn't have standing, or that Mr. Talbert didn't have standing. And finally, at Mr. Varghesi's deposition, where he was alerted to the fact that there was a share certificate that he signed to Mr. Talbert, then he started backtracking, and this story was started where, well, we weren't sure who we were dealing with. We don't know who that is, blah, blah, blah. The fact of the matter is, Your Honor, it doesn't matter who ended up with the share certificate. If Mr. Talbert, the owner of both Artis and IOC, wanted to give those shares to his son or to a family member or to some other entity, they're still his damages. And that segues into the damages element. I think Mr. Strother has kind of confused what our damages are. We have as part of this getting together in this relationship, my client was to be given $1 million worth of 4G stock. It was priced at approximately $1.75 a share, so a little over 500,000 shares. Those shares are now worthless. And that was admitted by Mr. Varghese during his deposition. Those are worthless. So that's the first part of the equation. And Mr. Strother used the $1 million of lost profits. That's not what we're talking about here. We're talking about the base number of shares, the $1 million worth of shares that are now worthless. On top of that, Your Honor, we've pled for lost profits on those shares. Now, Mr. Strother says there's no evidence of that. Again, Mr. Talbert testified during his deposition and as stated in his affidavit, neither of which are objected to for purposes of this hearing, that based on past dealings, not just this dealing, but on past dealings where his companies have done similar work, where they've gotten involved in barter trading and logistics and consulting, he recited 3 or 4 or 5 different instances where his company came in and the value of stock that they received as part of those transactions went up, say 3 times or whatever. So he wasn't talking about this case per se. He was giving examples of other situations and listed those names, and they're in our briefing in response to the summary judgment motion, where he shows not only reasonable certainty, but he has in fact done this on past occasions. Now, we know that there's no sure thing in a lost profits case, but he has proved with no objection to this evidence what he has done in the past as a basis for asserting those claims for damages, lost profits damages in this case, Your Honor. I see that you're about to ask a question.
Yeah, I'm kind of confused about something. So Artis had a relationship with Mr. Strother's client, right? They had an actual contractual relationship, correct?
Yes, Your Honor. And that was for domestic purposes. And then when this became an international deal involving the product in Mexico, I know we've talked about wearing hats, so I'll stick with that. The IOC, the international offset hat, everything from that point forward was under IOC, or Mr. Talbert was representing IOC going forward.
Okay, so I appreciate that. So the promises that were allegedly made to IOC are separate from the contractual provisions with Artis, correct?
Yes. Well, there is some overlap because they got together, you know, the claims in this case are separate from any Artis claims for breach of contract. That's correct. If that's, you know, there were some discussion.
For example, one of the things that they're claiming is that you don't have evidence of the consulting fees. Are those consulting fees that were promised? You're claiming, I guess, consulting fees that were promised to Artis or promised to, and I can't remember the guy's name, but the guy
Talbert.
Talbert.
Yes.
Talbert as part of this separate representation.
It's both, Your Honor. They're specifically stated in the Artis agreement. Mr. Talbert testified and stated in his affidavit, again without objection, that as part of the consulting for the defendants in Mexico and the Mexico opportunity, that those same consulting fees would be applicable. So they're in both places, both in the Artis written agreement and also on the IOC unwritten agreement, if you will, or course of dealing between the two parties. And again, there's no objection to his testimony in that regard. He's referring to those numbers because they were stated in the previous agreement, but it's a separate representation to him while doing the IOC work.
Your Honor, there's some things that, I'm sorry, Judge.
Yeah. So there were consulting fees of the $850. You calculate this at $850. That's the amount that he was to be paid under Artis. There is no separate. I guess your argument is that there was a separate agreement as the IOC, but that wasn't in writing.
Correct, Your Honor. And that's one of the elements of damages that's not. Again, it's in his deposition, it's in his affidavit, and there's no objection to that. Now, they obviously dispute that he should get anything for his work. Maybe they're alleging his work was worthless or what have you, but there's no objection to his testimony in that regard, that as part of this deal, he would receive those consulting fees from under the IOC umbrella, and he was not paid those. Now, that's a smaller piece of the puzzle compared to the $1 million of stock that's worthless, and the increased value that he believed with reasonable probability and certainty that he could obtain if this deal wasn't so messed up, if you will. We can get into the actual allegations of fraud, which kind of lead to why this stock is worthless, but it's two different things. Again, it's a little confusing with having Artis and IOC, but it's applicable to both, Your Honor.
And Your Honor, if I may have a moment to address some patently false things that were just put before this court.
Okay, go ahead.
Your Honor, first of all, IOC is not suggesting and has not suggested there is an agreement to provide consulting services at all. When Mr. McCaskill said that, it's the first time it's appeared, including in the evidence that plaintiff has presented. I would challenge plaintiff right now to point to any evidence that any party has put forth before the court that there's some unwritten agreement to provide this. Mr. Talbert instead is saying, in reliance on these other things, on reliance on the fact that you were going to sell 60,000 doctors and stuff, and reliance on the fact that you were going to update your records and your fees. I then spent time because I thought I was going to make money. So that is false. Secondly,
Your Honor, I agree. I can stipulate, we're not asserting breach of an agreement. That's part of our claim of damages for fraud and misrepresentation, that he wasted all of his time given these fraudulent misrepresentations. So to the extent, Mr. Strother, and if I misspoke, I apologize, we're not asserting breach of contract for consulting fees. It's an element of our fraud and negligent misrepresentation damages. And if I misspoke or muddied those waters, I apologize, but it's damages for the fraud and negligent misrepresentation, not a breach of contract where he would be paid X dollars per hour for Y number of hours.
And so secondly, Your Honor, you disappeared for a second and you're on, there you are. Secondly, Your Honor, Mr. McCaskill said, and just glossed over the concept, he said that there are emails that say that 4G was calling IOC its strategic partner. Where? I'm asking as a challenge where, because they don't exist. Mr. Varghese called Mr. Talbert on behalf of Artis his strategic partner. That doesn't equal IOC is my strategic partner. And it is a terrible misleading statement to the court to suggest that there is something in writing somewhere, either before the court or not before the court, where anyone says that IOC is a partner or strategic partner or anything like that with 4G or Mr. Varghese. It does not exist. That is a misstatement. The idea that we have not objected to these documents does not all of a sudden turn garbage into evidence. We didn't object to Mr. Talbert's affidavit. That's because it's full of no evidence. When he says I estimate I spent X hours and I estimate I spent Y weeks, we don't need to object to that because it just can't come, it's just not evidence. Mr. McCaskill also said that my client said that the stock was worthless. That's not accurate. It was Mr. Talbert who testified that the stock was worthless. My client said that the stock that 4G issued to Artis's company, Bragavan, hasn't vested because Artis didn't perform. And so therefore, my client takes a position that Artis and Bragavan don't actually own the stock, but no one ever called it worthless. My client does not believe the stock is worthless.
Or if I could respond to that, the issue of the stock vesting is another red herring they throw in there. When Mr. Varghese first said there was no stock issued, then we show him the stock certificate and he goes, okay, well, maybe it wasn't vested yet. There's nothing on the share certificate or any document that says you have to do this before this stock vests. And then later on, as you get towards the end of their relationship between Mr. Talbert and Mr. Varghese suggests that his company buy back that stock. Now, it begs the question of why would he be wanting to buy back stock that, quote, hasn't vested? It just doesn't make sense, Your Honor. There is evidence to support our fraud allegation in that regard and to refute this allegation or this insinuation that the stock, well, we don't think it exists, but if it does exist, it hasn't vested yet, but we want to buy it back.
But yet plaintiff says it's worthless and won't give it back. So it's just, most importantly, Your Honor, they haven't met the legal standard that they have to prove that they've been damaged in this regard. They haven't asserted that IOC was ever promised the stock. They instead, in his affidavit, swear that Artis was the one who was entitled to the stock. And there were other things in that affidavit that are worth pointing out that show that plaintiff's previous arguments a moment ago through Mr. McCaskill are false. Mr. McCaskill said you've got IOC.
Mr. McCaskill, can you show where it says in the affidavit that IOC was promised the stock?
I'm not sure it says that in the affidavit, but it talks in the emails, and these are exhibits 3A and 3C, I believe, that talk about the partner. Now, it's important to note, it doesn't say Artis is our partner. Those emails, Mr. Strother is correct in the sense it refers to Mr. Talbert. They're referring to a person, the CEO and the sole owner of IOC, but it doesn't say Artis is our partner ever. It's talking about Mr. Talbert, and those are in exhibits 3A and 3C to our response. His affidavit, I don't think, refers to the stock being directed or being referred to as IOC's stock. It is what it is, that the stock was given to Mr. Talbert personally, and then he allocated it to a separate company for whatever reason. So I don't think there's evidence, Your Honor.
What evidence is there that any statements were made to Talbert in his role as, other than just the email, he used the IOC email, that there were statements made to IOC?
All the statements, his testimony during his deposition and in his affidavit, more so in his deposition, were that he was wearing the IOC hat at all time. He was the only person. There were some instances of communications with his son, who's also an IOC officer, but all the communications from the defendants to IOC were through Mr. Talbert. So all of the stuff.
And Talbert works for both Artis and IOC, correct?
Yes, he owned both, worked for both, but his testimony during his deposition was that given that this was an international deal involving Mexico, he was operating under IOC, and he was the one. There wasn't a bunch of other people.
Is there anything in the affidavits or in the deposition where he communicated, he says he communicated that to Mr. Strother's client?
I don't think there's anything specifically to quote that exact wording, but he did say in his deposition, and it's recited in our response, that because it was international, he was dealing with the defendants using the IOC umbrella.
But what evidence is that they knew that, I guess?
Well, we don't know for sure. You know, they're denying that they ever knew IOC existed, even though we have
okay, so what evidence is that he communicated that to him?
Besides the emails that had the IOC, not Artis email, they were communicating with, the president.
I guess, show me an email that says, hey, on behalf of IOC, anything about IOC other than just the email address.
Well, Your Honor, candidly, that doesn't exist. He never put that as hey, just to be clear, even though I told you last week, I'm talking to you on behalf of IOC, there's no such email other than, he's the one that is the face of IOC, and he's communicating with the defendants using an IOC email rather than an Artis email. He doesn't, to your point, Your Honor, continue to read.
Is there any evidence that he presented that they knew that? Is there any evidence in any of the emails, any evidence that in any of the affidavits that they knew that they were dealing with IOC, that they say, hey, we promise IOC this, or on behalf of IOC? Is there anything like that?
There's no admission like that where they say, okay, we see IOC, or we admit this is IOC and not Artis, or they respond to the emails as far as, you know, the various allegations of fraud and negligent misrepresentation that we stated, but they don't come out and say exactly what Your Honor stated, that, okay, we understand that you're operating on behalf of IOC.
Mr. McCaskill, I'm really trying to help you here. I feel like you're trying to parse this so that I'm trying to help you. And so is there anything here where there's any communications whatsoever where either your client says in an affidavit or in a deposition or in any of the email communications anywhere that Mr. Strother's clients should have been aware or was aware that they were dealing with IOC?
In the deposition, Your Honor, and I'm flipping through my notes here to get to that, but during the deposition, Mr. Talbert was very clear, and this is attached as Exhibit 2 to our response, where he talks about the fact that he told the defendants, you know, this is an IOC deal, or has become an IOC deal with respect to Mexico. Not only just the emails that we've gone over a little bit here today.
So can you share screen whatever, can you just share screen whatever page in the deposition you're referring to?
I don't have that pulled up, but I can cite the court to it where it talks about
Mr. Strother or Mr. Coquet, I don't know how to say your name, Julian, I guess. Can you share screen the page number he's talking about?
Your Honor, I can do so.
Okay. What page are you referring to, Mr. McCaskill?
Yep, I'm pull that up. So this is what we called Exhibit 2. It's Mr. Talbert's deposition.
And what page?
Pages 13 through 16.
Okay, pull those up, please.
Yes, Your Honor.
And as Mr. Strother is pulling that up, this is where Mr. Talbert's talking about, since it's an international transaction, it'd be an IOC. If it was domestic, it would be Artis.
Okay, let me
Sure.
pull it up, Mr. Strother.
Almost there, Your Honor. Your Honor, can you see?
Not terribly well. Let me see.
I can blow up each page. Mr. McCaskill, did you say it starts on page 13?
13 through 16, yes. And then there's some other pages.
Your Honor, are you able to read that?
Yeah.
If you'll direct me when you want me to move pages.
Okay, next page.
Let's see. Page 14.
Okay, keep going. Keep going. Okay. Keep going. Okay, keep going to the next page.
Oh, here we go.
I still don't see, Mr. McCaskill, where it says that he told him he was working on behalf of IOC.
And Your Honor, I would represent that it doesn't exist. And that's why
I'm talking to Mr. McCaskill.
Well, let's also jump ahead to pages 51 and 52. And again, this is where Mr. Talbert, it's a same exhibit, pages 51 to 52. Mr. Talbert's again talking about Artis and IOC, and he's talking about IOC working with its client, in this case 4G. Now, to Your Honor's point, that's not reciting that I told them on this date that I was wearing the IOC hat, but Your Honor, it provides some evidence I would submit that he was operating his client, the client was IOC's client at this point.
And Your Honor, I can take you to Mr. Talbert's affidavit, which was attached to this response.
Okay.
To refute the argument that this started as Artis, but then when he learned it was Mexico, it changed to IOC.
Okay, let me see that.
Apologize for making the screen go. Okay, here we go. Okay, here's this is page 37 of plaintiff's appendix. I've
Okay.
highlighted everywhere Mexico applies. So starting at 6, Mr. Talbert says, starting in November 19th, he talked with Varghese regarding glucose reverse in Mexico.
Your Honor, if we could stay right there, there's where it talks about IOC. I misstated when I said something about the affidavit. That's Mr. Talbert's affidavit where he's talking about negotiations about IOC investing in 4G. And then if you look below at number 12, it talks about issuing the stock to him on behalf of IOC. Again, no objection to this affidavit.
But except that it's not evidence. Your Honor.
Well, the judge will decide that, but for purposes of summary judgment, there's some evidence whether the jury.
That's what I was looking for. That's what I was looking for. Okay. So on the standing issue, I mean, I'll be honest with you. I don't fully understand why you're not bringing this claim on behalf of Mr. Talbert individually and on behalf of artists, but I do think they're standing to make this fraud claim. So I'm going to deny the summary judgment of the issue of standing. So there were 5 other issues here. I think, where does it say that there was some kind of promise made as to the consulting fees for IOC?
There's not, I don't think that's in the affidavit. I think that was in his deposition testimony. Which
where in the deposition?
Again, that Justin, that's exhibit 2 at page 91.
Okay. Let me see.
Yes, Your Honor. One moment.
And it is in his affidavit, he recites these numbers, affidavit at page 7, but we'll go to this deposition first. At the bottom of page 91, which is the bottom left corner of our screens, it talks about working hundreds of hours on behalf of 4G. He's using the number that was in the artist agreement, nothing more, nothing less, but he's talking about his consulting, which is separate from the barter agreement. He's talking about consulting for the defendants on behalf of IOC on the Mexico part of the deal.
All right, denying summary judgment on the consulting fees. What about this $20,000 expense and the advertising fees? You didn't respond to that?
We did respond, Your Honor. We did not submit or provide receipts from plane tickets or anything like that, but Mr. Talbert has testified that that was the number as far as out-of-pocket expenses. He does not have the receipts or the plane tickets or whatever, but he testified to during his deposition, and it's also on his affidavit, I think at the second to last section of his affidavit, where he talks about the $20,000 in out-of-pocket numbers. So that was responded to in the response. Evidence was provided from the deposition and from the affidavit, again, not objected to. I understand that they disagree and say that there should have been receipts, but we don't have those. We have his testimony as to his personal knowledge of his expenses that were out of pocket for this transaction.
And Your Honor, it is not in the response. It's just not. It may very well be mentioned in his deposition at some point, but as far as in response to our no evidence motion.
Mr. McCaskill, do you cite anywhere in the response itself to this $20,000, his testimony about the $20,000?
I don't think it's in there other than the affidavit that's a part of the response, Your Honor.
MSJ is granted on the expenses. What about these advertising expenses?
I think that's one and the same with and that's where I think there was some confusion. Advertising expenses were part of the $1 million, where the defendants themselves called it an advertising investment by Mr. Talbert. So I think there's a little confusion on terminology, but I don't think it's a separate category. And to the extent it is, I don't think we're asserting that. I think the advertising investment was some name that the defendants gave to the $1 million.
Is it listed? Is there a separate blank within the either asserted? Is there a claim made in the petition or in the responses to request for disclosure regarding advertising expenses?
Yes, Your Honor. Their request for disclosure response on damages explicitly split out advertising costs and didn't identify what they were.
Your Honor, I think those, if anything, were part of that 20,000 that your Honor's already referred to or ruled on.
Right.
So again, I think it's, go ahead.
I'm granting summary judgment on the advertising expenses, denying on consulting, lost business opportunities. What evidence is there of that?
Mr. Talbert testified during his deposition and also in his affidavit that as part of their work, working in Mexico or on behalf of the defendants in Mexico, they had to forego other opportunities that caused them to lose that other business because they were singularly focused on this opportunity with the defendants. So he testified, again, there's no objection to that evidence in his deposition and affidavit, that there were other opportunities that he and his business could have undertaken, perhaps would have turned out better than this. And that is the sum and substance of that.
I'm going to deny summary judgment on that. And then I think the final thing was your second point about damages. Go ahead and respond to that.
Actually, Honor, before you move on, you didn't talk about the $1 million in profits nor the $1 million in stock.
Yeah, so there's an argument about $1 million in profits and stocks. Mr. McCaskill, where does your client respond to that?
It's on page 31 of our response, and you just saw it a few minutes ago in the affidavit where it refers to the stock going to IOC, obviously through Mr. Talbert, but to IOC. So that's there's a difference between the underlying $1 million worth of stock that we looked at just a moment ago. Then there's also the lost profits, which is separate, where Mr. Talbert testified during his deposition and in his affidavit, where based on the 4 or 5 other cases or situations where he had done similar barter and consulting work for a small startup, where he had made increased the value of the stock that he received as part of those deals. And thus that was part of his claim for damages in this, but it's separate from the underlying base $1 million. Then there's the lost profits on that stock not going up. If it would have gone up, as Mr. Talbert's assertion, if the status of the company was as represented to him, which it wasn't, and that's the underlying part of the case.
Okay.
What Mr. McCaskill just said is literally what the Texas Supreme Court says you cannot do, which is just say, in my opinion, I have these lost profits of $1 million based upon my experience on other products. The Supreme Court requires reasonably certain evidence about an unproven, untested product, and it can't be done here. It's, as a matter of law, they can't recover those lost profits. How would my client even defend against it? He's not provided a calculation. He's provided no underlying data. He's got no expert. And Your Honor, if I could ask you for a point of clarification regarding the lost business opportunities, that's the one that Mr. Talbert said in his deposition that he would not identify the lost business opportunities to us, and so he wasn't going to seek them. So I don't know.
That's right. He did say that, Mr. McCaskill. Is that accurate?
That's correct, Your Honor. And we'll withdraw that element, if you will.
Okay.
But Your Honor, I would be happy to share my screen and show you their response again regarding lost profits. They, without exaggeration, don't tie it into anything other than some experience he had 20 years ago, increasing the value of companies from 3 to 1 to 10 to 1. Even if I were to assume that that were true, it has nothing to do with what the lost profits are with regard to an untested product, glucoreverse, with regard to 4G.
Response.
Yes, Your Honor. During the deposition and in the affidavit, Mr. Talbert testified that he had past experience where in similar situations with startups or small companies, the stock represented a baseline. That stock would become worth more after we invested our time and efforts to get the company on track. And then he used the 3 to 1 to 10 to 1 numbers that Mr. Strother has referred to. And again, referring to when IOC got involved in an equity position with the company, the stock had gone up in these other situations. Now, again, we don't know what the future would hold with respect to 4G, or maybe we do now, but he has evidence with reasonable certainty what he had done in very similar circumstances where it had worked out in the numbers or in the positions that he had testified to with what he expected with respect to 4G.
And Your Honor, I believe that in his deposition, and we cited to this in our motion, when I asked him how he calculated that evidence, because Mr. McCaskill just said, no one really knows for certain what's going to happen in the future. Mr. Talbert admitted that it was speculation because we're dealing with an unsold, unmarketed product. He can't go back 20 years to his work with Texas Roadhouse or an internet company called Earthlink and say, I did a good job for those people, so I know I was going to do a good job for this untested product too. The Texas Supreme Court in the Texas Instruments versus Teletron case says that you just can't recover them in that instance. They're not recoverable as a matter of law. You have
How do you distinguish those cases, Mr. McCaskill?
Well, of course, every case is different, but in this case, what we have in those cases, I don't think there was evidence from the proponent or the affiant saying, I've already been there and done that in other situations. I have experience doing this, so I'm qualified to give that opinion, and I can cite to previous examples of real world cases where I have done this. And it's not where someone else in his company that managed to turn these companies around or make them more valuable. It's Mr. Talbert himself, based on his own work, his own experience. He's qualified to render that opinion and also has the basis from other situations to apply it to this case. Now, whether the jury believes it or not, time will tell, but there's some evidence without objection on that element of damages that there could have been, perhaps if things weren't so badly misrepresented to my client, that there could have been an appreciation of value in the stock on the underlying base of $1 million, which again is a separate element of our damages.
And Your Honor, he's not distinguishing the case law from the Texas Supreme Court that says you can't present that to the jury. And I don't need to object or disprove it. It's insufficient as a matter of law to go after lost profits when you just say, I'm a really good businessman. I can increase values of things by 3 to 1 to 10 to 1. That's literally his testimony. And when I say, well, what did you do previously? Well, I worked for Texas Roadhouse. What did you do? Oh, I just made it better. Who can I call to check that out? Oh, I don't know. It's been 20 years. That's not sufficient. That constitutes no evidence under Texas Supreme Court case law.
All right, this is what I'm going to do just to kind of summarize. On the issue of standing, I'm denying summary judgment on the issue of consulting fees, denying summary judgment on the issue of the $20,000 in expenses, the advertising fees, and the lost business opportunities I'm granting. On this final issue, I think it's kind of a close call. I'm just going to take it under advisement, and we'll just, as we get closer to trial, we'll kind of figure out if we're going to go forward on that one. But I will say that, Mr. McCaskill, that based on the evidence you have so far, I don't think that would get that. I don't know if is this a jury or non-jury case?
That's another question we had for Your Honor. I know there was, I think something came out today about jury trials and with COVID and all that. I think both counsel, I'll let Mr. Strother speak for himself. I thought we had requested and paid for a jury trial, but I think when we checked that this was listed as a non-jury trial, trial set for later this month. So,
oh, wow. Okay. Let me take a look at it. I don't know off the top of my head.
And so Justin, if I've misstated any part of that, I know we've had some arguments about misstatements today, but I think that part, I think we can agree on.
Yeah. My understanding was that it was a jury issue. And for the record, let me say, I have nothing but admiration for Mr. McCaskill. I don't think he's intentionally misrepresenting anything to the court. They're just not.
So it's set on the 25th. Let me see if we have a jury fee paid real quick. Oh, shoot. Financials.
And Your Honor, while you're looking, if you will allow Mr. Sokich to address the individual issue using a few minutes.
Okay, give me a second first. Let me check in the middle of this. Financial. Okay, there we go.
I think Ms. Becken called the court as we were getting ready for this hearing in consultation with Mr. Strother. We were just checking the status of the docket with an upcoming trial setting. I think it was Ms. Becken that noticed that it had been designated for non-jury. So we're relying on her accurate recitation of what's going on. But
no, she's right. It is indicated as non-jury. I'm just seeing if you paid a jury. It has happened before where we miss that and it's misdesignated. I don't see where you paid a jury fee, but do you know when you paid the jury fee?
I don't recall when plaintiffs would have. I kind of thought that it was the defendants that were more interested in the jury trial rather than non-jury trial, but that's for Mr. Strother. But if he says he paid it, I have no reason to doubt it. I think they did.
I don't see that it was paid unless it was paid as part of the original filing of the case. You said it was filed later.
Yeah, I don't believe we made a jury demand or paid a fee Defendants are happy to tee it up either way.
I mean, if nobody's paid a jury, let me just kind of talk big picture here. You know, just generally, I'll just talk about generally, nothing related to this case in particular, is that the courts, and I'll just say my court, is very backed up because we haven't been able to do jury trials consistently over the last, God, it's almost 2 years now. And so to the extent that I can try cases non-jury, I'd prefer to do that if we can, just because I know that I can go forward with a non-jury. I do them over Zoom and, you know, nobody gets sick and it's a lot, you know, safer. But that being said, I'm also a strong believer in jury trials. And so, you know, if the parties all agree to a continuance and they want it to be reset, I'm not necessarily opposed to that. And this is not that old a case, although it's, you know, I would be fine trying it. So, but realistically, if you want a jury trial, it's not probably going to go that date. The earliest I'm really resetting cases to is November. So just because we're so backlogged. So if you want a non-jury case, I could try it. I'm pretty certain on the January 25th. And if, you know, after that, I just don't know, because I don't know how long. Right now we're in the middle of this new Omicron surge. And if that goes away, then, you know, and it clears up and things get better and we go back to orange, then I could start doing jury trials again in February. I'm trying cases when I can. If we get to orange, I try cases. But I don't know the future. And so if you're trying to get this done quickly, your best shot is to try to do it as a non-jury on January 25th. If you don't really care about that, or you really want a jury trial, then I would suggest, and you want to reset, I'm going to probably not reset it until as a jury trial until November. And the reason for that is that I try not to have more than 15 cases set a week or a special setting. So either I have a special setting or a non-jury. The last time I checked, which was last week, I don't think I had any days between now and November where I didn't either have a special setting or 15 cases set. I don't know if that all made sense, but so bottom line is, you want a continuance and you want a jury trial, I'm going to set you in November. If you want to go forward, I'm pretty certain I can try it as a non-jury on January 25th. I don't foresee I could try this as a jury case then, just given the surge. So what do y'all want to do?
I think that's been very helpful, Your Honor, and I think exactly what we were kind of both looking for as far as guidance. I would suggest that maybe Mr. Strother and I can visit offline. Sure. And sort of decide what we're going to do or what works best. We're both also involved in other cases before Your Honor, significant, you know, large cases coming up, I think, in February and or March. So we'd have to figure out how that all fits in the puzzle as far as getting ready for multiple cases at one time. But I'll represent that we'll work together offline and get back to the court ASAP with what we're going to do, whether it's going forward on 25th or not.
And I want to clarify something, because I don't want there to be a misunderstanding. I'm talking about this case. If you already have a case set in February, I don't know what's going to happen with that, if that's going to go forward or not.
Right.
I'm just saying, resetting this particular case, given the age of this case, I would reset it to November. That doesn't mean that if there's I think I know the case. Are you involved in that?
Thompson versus Rudnicki?
Yeah, Thompson Petroleum case. I'm not saying I'm resetting that case at this point, because I don't know. Right. I don't want that to be misunderstood, because that case, I would really like to try that case if I can, any way I can.
I understand. I have a small role in that case with respect to drafting the jury charge. I know you're working with other lawyers from our firm on that case. So yeah, I'm not suggesting that at all. It's just a matter of I may have to put aside this case to get ready for my part of that case. Again, not knowing what might happen in the future.
That case,
and I think Mr. Strother,
if they're both jury cases, that case would definitely take precedent over this case, given the age and factors in that case. And so I just
I
don't
think
want there to
Mr.
be any misunderstanding.
Yeah, I think Mr. Strother had a similar issue where an older, bigger case set for sometime February.
6th or 9th, I think. Yeah. 8th. So, but I
And,
understand Your Honor.
and one last thing I didn't address, if you disagree, let's say, Mr. McCaskill, you want to go forward with this as a non-jury, and Mr. Strother, you want to go forward with this as a jury, and there has not been a jury fee paid at this point, then you're going to trial on January 25th. Or you're potentially going to trial. I'm not going to move this if one side wants to move and the other side doesn't, and there's no jury fee paid. So I just want to kind of, I don't think
Understood.
I addressed that particular issue. So, but I'm not testifying 100% or saying 100% that I can tell that it wasn't paid, but based on what I can see, I don't think a jury fee has been paid. But if there's some proof to the contrary, you want to look that up and figure it out. But currently, from what I can tell on the docket, it's a non-jury and no jury fee has been paid, and you're within the 30 days, so you can't pay a jury fee unless you guys agree to move it.
And we'll have those discussions offline. And we've had a good relationship in that regard as far as logistical things.
Do you guys want to come back at 1:30 and chat with me about that, or do you need more time?
Your Honor, I think I would need a little more time.
Okay.
I don't know what my client's going to say or what Mr. McCaskill is going to say, and it probably will take just a little bit more time to figure it all out.
Do you want to come back tomorrow morning at 9 and talk about it?
Sure.
That's fine with me.
Go ahead and get a link from Rhonda. We have a Zoom conference. It looks like our one trial that we had tomorrow, they've moved for a continuance. So we do have another status conference. So you can just be added to the status conference docket and we can just chat about it. And,
or if we come up with something this afternoon, do you want us just to email Ms. Pinson and say, hey, we're going to do this and we don't need to take up the court's time tomorrow? I'm happy to jump on tomorrow as well.
The only way I would say that is if you agree, if you're going forward with the non-jury case on January 25th, you don't need to do anything else. That's
Okay.
what's scheduled. If you want to do something different, you need to talk to me about it. And then because you may agree, hey, I want this to be reset in August. And I'm like, sorry, that's not an option. So you'll need to talk to me about what are the options. And there may be some way that we can fit this in sooner than November, but I don't anticipate that. So I want to talk to you. So if you agree just to go forward with the non-jury, you don't need to meet with me again. Anything else, you would need to meet with me tomorrow at 9.
Thank you.
Honor, if we do end up needing to meet with you tomorrow at 9,
Mhm.
may I request permission to attend by telephone rather than video? I just realized I have a 9:45 appointment with a doctor about my shoulder.
Okay.
Thank you, Your Honor.
Can you just call into the Zoom?
Yeah, I can do that, Your Honor.
That's fine.
Yeah.
Happens all the time. Did you say there was still one other issue in the summary judgment we need to talk about real quick?
Yes, Your Honor. The issue of these individuals who we believe don't owe a duty to disclose, and that would be Mr. Sokic's issue, if it would please the court.
Why don't we do this? Because we're way past time and I need to take a break. Why don't we do that tomorrow morning? Is Mr. Sokic also, are you available tomorrow?
I should be. Yeah.
Mr. McCaskill?
That's fine with me. We can do it tomorrow morning.
Okay. And I actually know it. Let's just see if we can finish it quickly now, and then you can give me an order on everything. That would make it actually easier. So go ahead and make your argument briefly.
Your Honor, there's 3 defendants, defendant Kenneth Brown, Charles Clayton, and Sam Laird, that there's no accusation that they made any misrepresentation at all. The accusation against them is that they remained silent while defendant Roy Varghese made a misstatement. Generally, there's no duty to disclose or correct somebody else's statement in Texas. There's narrow exceptions where there are. And the most commonly used exception would be a fiduciary relationship or an otherwise special confidential relationship. There's no relationship of any sort between those 3 defendants and IOC. IOC responded that those 2 emails in which Roy Varghese, not the 3 defendants, emailed a third party calling Mr. Talbert a partner, made an argument that somehow creates a partnership between the three individual defendants and IOC, which it does not. Other than that, there is no relationship between those parties. Separately from that, IOC makes the argument that they are both shareholders. IOC is a shareholder, and those three defendants are shareholders in 4G. Again, as Mr. Strother discussed, IOC has not presented any evidence that they are shareholders in 4G or NutraSpace. However, even if they were, being a shareholder in a company doesn't create the duty to disclose. IOC cited a case, which is the White versus Zhao Pei case for the proposition that shareholders owe each other duties. That's not what that case says. That case talks about an even more narrow exception where if a party makes a partial misleading disclosure that they, if they're in a transactional relationship with the other party, that they then have a duty to correct that partial misleading disclosure. There's no misleading disclosure alleged against these three defendants. So that case does not apply. That generally sums up the argument, is that these three defendants did not have any duty to say anything or correct any statements made by some other party. They didn't have a relationship with IOC.
Okay, response?
I think I can do it in 1 minute, Your Honor. On February 27th, 2020, there was a board meeting involving these individuals and Mr. Varghese and my client, Mr. Talbert, where admittedly Mr. Varghese was doing most of the talking and, in our opinion, making misrepresentations. And these other directors and owners of 4G were nodding along. And the White case that we cited and counsel just referred to, it's at page 29 of our response. It does say exactly what it purports to say, where shareholders do have a duty to their fellow shareholders. In that case, it was involving the company was selling some assets, and some shareholders knew about it and other shareholders didn't know about it. And the ones that did know about it,
but your client's not a shareholder, right?
He is. There was that discussion about the share certificate where, he was given the share certificate. He allocated it to a separate holding company for whatever reason, taxes or whatever. But he was a shareholder, and Mr. Varghese, after we got past the initial denial, admitted that he had signed that share certificate for 500 and something thousand shares to Mr. Talbert. But in that case, and counsel kind of started getting into it, but it talks about when you start talking about the company to your fellow shareholders, you have the duty to disclose the whole truth concerning the company. And that's at page 538 through 539 of that opinion. It's from the Houston Court of Appeals in 2014. And the problem with it is that, and this is a quote, the shareholders provided incomplete information that created substantially false impression and failed to provide the full truth. Because of that, Your Honor, the Court of Appeals held that there was a claim against the fellow shareholders who remained silent, who let someone else make misrepresentations, and thus the fraudulent concealment claim was allowed to go forward. I think I went a little over a minute, but that's the thrust of it, and that pertains not only to the February 27th, 2020 board meeting, but other interactions, but that's the main one. Thank you, Your Honor.
Response?
Yeah, Mr. McCaskill basically said what I said, just didn't, not in his, didn't distinguish what the court actually decided. The court did not decide that shareholders owe other shareholders a duty to disclose. I mean, practically, it would make trading shares impossible if a shareholder had a duty to give full information or give additional information, wasn't able to remain silent about things that they knew. What that case is saying is that shareholders in a closely held corporation that affirmatively made misleading statements, and the statement was they misled the other shareholders in the company, I believe there's 4 or 5 shareholders, to believe that the company was a going concern. And what was really happening is that those shareholders, the defendants in that case, were selling off the assets. There was an imminent sale of assets and an imminent sale of the company's business. And what that court said is, in this case, if a shareholder in a closely held corporation gives partial misleading information to the other shareholders, they have the duty to correct that partial misleading information.
So Mr. McCaskill, in that case, maybe I need to see it, but in that case, was it a situation where they just didn't say anything when they knew the truth, or they made a misleading statement and then didn't correct it?
I think it was both. And in this case, we have the same thing on page 30 of our response. And this is as part of Mr. Talbert's deposition testimony, where he testified, Mr. Varghese, Mr. Laird, and Mr. Clayton told him that about this there's a board meeting issue about having board meetings and board seats, where he names all three of these guys. Well, Mr. Varghese plus two others. Elsewhere, and that's on page 46 through 48 of Mr. Talbert's deposition. Then on pages 58 through 60, Mr. Talbert again testifies that Varghese, Clayton, and Laird, the other individual directors, told him that 4G would be providing current financial information because 4G had been delinquent on current financials. So there is evidence that these other individual directors and owners made statements. Not only did they just sit quiet while Mr. Varghese did the talking, but Mr. Talbert has testified without objection that these other individuals made statements that implicate them under the same analysis as the White case.
So I didn't get, you kind of went through that quickly. There were three other individuals, and he implicates two other individuals in the first statement, and then two other, between the two, is it the same? I couldn't tell if it was the same two each time, or
he named Mr. Laird and Mr. Clayton, and then later Mr. Clayton and Mr. Laird, and then on another page of his deposition, page 43, Mr. Talbert refers to Mr. Brown, or Dr. Brown. I think he's a doctor. So within those 10,
what does he say about Brown?
Failure to raise money and secure the funding for the gluco reverse product. That's one of our allegations of fraud, that they claimed they'd raised this money when they really hadn't.
And if Mr. Brown said that?
Mr. Brown made a statement regarding the raising of money, or what turned out to be lack of raising of the money, and that's at page 43 of Mr. Talbert's deposition, where Mr. Talbert names Mr. Brown as making a statement. Later on, those other pages that I referred to discuss Mr. Clayton and Mr. Laird in both instances. So there is evidence from Mr. Talbert as to these individuals making statements, not only staying quiet while Mr. Varghese made representations, but there's also evidence without objection that these individuals made statements to Mr. Talbert that he relied on.
Response?
Yep, just to address that, Mr. Talbert testified that these three defendants, Clayton, Brown, and Laird, did not make affirmative misrepresentations. And although Mr. McCaskill is giving the impression that they did, what he's referring to is a statement, a purported statement, or alleged statement, where two of those defendants stated that there would be a future board meeting, or implied there would be a future board meeting. That was a February 27th meeting, and by the following month, the relationship with Mr. Talbert and all of these defendants was over. So in that instance, there's no argument or a plausible argument to how it was a false or misleading statement that there would be future board meetings. The next statement was that they stated that those two of those defendants, I believe it was Clayton and Laird, stated that 4G provided incomplete information and that they would be giving or providing future or current financials from the company to Talbert. There's no argument that that's a false statement. Again, this is at the February 27th meeting, and they said they're going to provide updated financials. Within a month, the relationship was destroyed. There's no allegation they concealed something. There's no allegation they failed to disclose something. Just that they made a statement.
All right. I've got enough. The summary judgment's denied on this point. Okay. Can you go ahead, Mr. McCaskill, go ahead and prepare an order? I know that there's, I ruled in both sides' favor on this.
Right.
Make sure at the beginning of the order it says this was heard on January 10th, 2022. Share this order with Mr. Struther. Or do you want Mr. Coaches to do this since you're going to be in this doctor's appointment? Mr. Struther, you're
muted, Justin.
I apologize. He can send the order to me, and I can help with it. Yeah.
And I'll have it to you, Justin, within a couple hours, so that if there's corrections or modifications, it'll be pretty vanilla. I think I caught what the court's rulings are, and then we can have it ready to go for Your Honor to look at tomorrow morning at 9 o'clock.
Perfect. That's what I was going to suggest.
Okay.
Great job, guys. Good briefing on both sides. And we will see you guys. I guess either way, we'll see you guys tomorrow morning.
Thank you,
Thank
Judge.
you for all the
Your Honor.
time you spent on this. We all appreciate it.